Welcome to Consumer Law, What Is It Good For? The series where we look at, consider and try to answer frequently asked questions that come to us at Stormcatcher Law through our free legal advice helpline or from clients. And today's question is really two questions, which are two versions of the same one, if you like. And the first comes from Daniel, and it's in respect of a decision that he's received from Oodle Car Finance, who has rejected his complaint because Oodle say the highlighted issues would be classed as general maintenance and not considered as premature. And the second is from John, who has received a letter from a lawyer in reply to his faulty car complaint, which states there is an implied exclusion of wear and tear items that sporadically fail. And the implication is that the matters that John's complained about fall into this category. Both Daniel and John want to know whether the statements are true or whether there's any truth in them. So by way of some background, both Daniel and John coincidentally both bought Vauxhall cars, but the issues that they are referring to will occur in any car. It's not brand specific. And both of them presented problems within a couple of months of purchase. The first, that's Daniel's, involves diesel particulate filter requiring cleaning, the AdBlue injector requiring replacement, the AdBlue tank requires replacement, and so do both NOx sensors. The second, John's, involves the oil pressure warning light coming on, there being excessive play in the turbo bearing, a noisy timing chain and noisy bottom end of the engine, most likely to be a big end bearing or crankshaft bearing failure. The starting point is the Consumer Rights Act 2015, and we have to go through a little checklist to make sure that it applies. And the first is both Daniel and John are consumers. Tick. The second is that both complaints are supported by documentary evidence by way of diagnostic reports from independent mechanics. Great. And finally, both cases, as I've just said, arise within 6 months of purchase. So at face value, the Consumer Rights Act applies. But we have to put the complaints into perspective by considering whether the vehicles conform to the contract. That's to say whether or not a reasonable consumer would think the vehicles were satisfactory quality and in consideration of their age, their mileage, the price and the description. And it is again the position of both Oodle and the lawyer that because of the age, mileage, description of the vehicles, that the parts that require replacement were foreseeable and part and parcel of wear and tear. But let's look at each statement in turn. First of all, Oodle. The implication from Oodle's response is that the problems with the car and the need to replace the parts is simply because the parts have reached the end of their expected life, as opposed to them having failed prematurely. The problem is, from Oodle's perspective, is that they bear the burden of proving what the expected lifespan of these parts are, and then they have to compare and contrast that expected lifespan with the lifespan of the period in which the parts have lasted to determine whether or not it was expected or unexpected. And no evidence at all has been provided by Oodle at all. The second problem is that if Oodle are right, which there's no evidence to say that they are, and that the parts were going to fail and require replacement imminently, which cost together well over £4,000, not far off of 50% of the price of the car, then it seems reasonable that Daniel should have been told about this before he bought it. And finally, given what we know about plastic in the ocean, plastic in the countryside, and how long it takes for that to degrade, one has to consider what the expected lifespan of a plastic AdBlue tank is. Additionally, it does seem a little bit odd to me that the diesel particulate filter, both NOx sensors, the AdBlue injector and the AdBlue tank all require replacement at the same time. And I can't help but think that these issues are symptomatic of a bigger underlying problem with the vehicle. But the long and short of it is, Oodle have not provided any evidence at all, and therefore, by declining, there is no basis for them to decline liability. Now for the lawyer, for John's case, who says there is an implied exclusion of wear and tear for items that sporadically fail. That's just wrong, and I'll explain why. There will be parts of a vehicle that are intended to last the life of the vehicle, and there are parts that will require replacement due to in-service wear, which are generally referred to as wear and tear parts. But there is no automatic exclusion under the Consumer Rights Act or any other law just based on the category in which that falls into. And I'll explain why by way of an example. This is just an example, by the way. Let's say that I bought a second-hand car a month ago that had just at that time passed its MOT, and within 2 months I had cause to replace 2 tyres. Now, the reason for replacing those 2 tyres is probably one of 6 possibilities. It could be 1, that I've been driving heavy-footed; 2, that the tyres were punctured; 3, that someone has slashed my tyres and been vandalised; 4, that the tyres were faulty; 5, the tyres weren't suitable for the car, because tyres have different ratings and different weight categories and so on and so forth; or the car is faulty. So we can't exclude liability just because of 3 out of the 6 possible causes of the tyre requiring replacement falls on my doorstep. Instead, I have to prove that the need to replace the tyres is because either the tyres are faulty, the tyres are not suited to the car, or there's something about the car that has caused the tyres to require replacement. So we can see that there are at least possibilities that one has to consider as to why these tyres require replacement. I'm reminded of a situation that happened quite early on with the take-up of electric vehicles, and there were lots of cases where people were coming forward explaining that their tyres seemed to wear unexpectedly quickly, and the reason for that was that the EV, the electric vehicle, weighed about 3 tonnes compared to the internal combustion engine version that weighed about 2 tonnes. So there was absolutely a reason that was outside the control of the driver for these tyres to require replacement much, much quicker than one would expect. So in summary, the reasons given by Oodle and the lawyer for not upholding the complaint are unsustainable. And while there'll be many occasions where things like brakes, clutches, tyres, exhausts, and lots of other parts that require periodic replacement as part and parcel of routine maintenance, there will be occasions where these parts fail prematurely, and there will be occasions where the reason these parts require replacement is symptomatic of an underlying issue with the car or the parts for which the seller may be liable. So it's wrong just to simply discount something or hide behind the fact that they're wear and tear parts. So I hope this video has been useful. If you've got any questions, send them in. If you've got a different question, give us a call. If you need some legal advice, give us a call on 0333 700 7676 or email us at knowledge@stormcatcher.co.uk.